On behalf of the defendant?
How we know. The question here is who? Mr. O'Brien, Ms. Rouse, Ms. Cooling, Your Honor, distinguished co-counsel Isabella, Anthony, Amy, Carla. Ladies and gentlemen, I'm gonna need the electrum because I don't have the strength I used to have, so if you bear with me a minute. Good morning. We started this process on February 3rd. Now we know you came down on January 24th and we went through some stuff, but this process, this particular trial, we started on February the 3rd. And we started with a process called voir dire. And Ms. Dixon asked you some questions. Ms. Rouse asked you some questions. I want to express my gratitude on behalf of my co-counsel, Anthony, and the parties for your willingness to serve also. I agree with Ms. Van Coolen that as attorneys or parties in terms of trying to deal with this, oftentimes, we human beings, we may hear evidence that's different from the way you folks remember it. And again, I will mirror Ms. Van Coolen. If I say something during the course of my presentation, disregard what I say and rely on your collective memories. I won't do that on purpose, but I can make a mistake. So that can't happen. If, during the course of these proceedings, I don't know if I had a chance to tell you folks, but if I do something, or I said something, or my co-counsel said something that offended you, maybe it's probably me, but hold that against Larry Thomas and not view the evidence against Anthony Parton. Hold that against me. And I think you will. If he got that kind of hold it against me. I think that we know, I think you were asked about this, and this was going to be a tough process. We had kind of anticipated what you were about to hear and see. And we asked you about that extensively because we know that as a human being, if you got any kind of heart at all, and you see what you saw, and you heard what you heard, it would be impossible not to have feelings, not to have emotions. And I think that's what we have to, and that's what we rely on you folks when you say it. You can set those feelings aside. You won't get an instruction from the judge that tells you there's a problem when you let sympathy and bias enter into your thinking process. Because then it affects the way you look at the evidence. If you're feeling a certain way, you tend to look at the evidence to support the way you feel. So we ask you not to do that. And each and every one of you took an oath and said you would do your best not to let that happen. Uh-oh. If I fall, anyway, I move a lot. Y'all know that. But the point being, a lot of the arguments you hear is actually asking for your sympathy. We know how this thing happened. That's not an issue. And yes, it was terrible. In our own house, this and that. Soliciting sympathy. You have to put that aside and look at the facts facts as they were presented. Not the sympathy. That's the hardest part. That is the hardest part, but you said you could do it. Well, look, she was this and this and this and this. Of course, we know that. But what we don't know, and what we can't put together, is who. Who did this? You've heard from the experts, you've heard from, I think, 14 witnesses. 13 live witnesses in an interview with Anthony Sleet. And I would disagree with the state because I don't think not one witness came in here and said Anthony Parton was in that apartment. Not one. Detective Howe told you that he gave you that map, showing you where the phone hits. Could be anywhere. Could be. Ladies and gentlemen, those are key words. Could, may, might have. When you ask yourself that in the back, that means the state has not proven to you, beyond a reasonable doubt, that it is. If they say Anthony could have been there, what does that tell you? Reasonable doubt. Because they didn't prove he was. If it could have been his DNA included in a YSTR, what does that tell you? Reasonable doubt. Because they can't say, beyond a reasonable doubt, it was him. When the Detective Howe gives you that scenario, and he said, well, Mr. McCool says it's not cherry picking. Tell you why it's cherry picking. What is missing from that display? Rachel's car was brought back to the apartment. What now? Why don't we have a trail showing you see one going down James Road, see one going down Main Street? Why didn't we have one showing who bought that car back? The car was bought back. If Anthony Parton's phone was part of that car, then shouldn't you have some showing where that car was bought back and him being in that vicinity another time? Was it there? That's what I mean by cherry picking. On those 4,000 or whatever pages, it doesn't show you that. You know why? Because it doesn't show Anthony having that phone in that particular car. The state wants you to jump to a lot of conclusions. They want you to say, well, I'll tell you something else, but I'm going to get back to that. Anthony Parton used a credit card. And you heard from every witness that came up, object was to tie Anthony Parton, the marriage, credit cards to the homicide. The use of the credit cards to the homicide. Because they couldn't put him in the apartment. Couldn't put his DNA on the murder weapon. Say, I'm going to give you an example. Detective Hurst came in, and I don't know if you heard, or maybe it's just me, could be my imagination. He clearly explained to you that he took swabs. You'll go back there and you'll have an exhibit 65, where he swabbed the curling iron and the dryer, hair dryer. And when he swabbed that, I asked him, he told you folks, I was careful to swab the areas where somebody would touch. I would do that. That was when he did his investigation. Now, for some reason, those swabs we don't hear about no more. And I asked him, I said, well, Agent Durst, it's good to put these things together. Can't you have that transfer of DNA? No problem, I can do that, it's not a problem. And he packaged them together, sent them down to property before Miss Simon got them, and separated them out. You'll see them in the photographs where she separated them out. But then, they had a suspect, and they had a sample of Anthony's DNA. The swabs that were then tested for those two items now have Anthony's DNA. Now, what's unusual about that? Well, okay, mister, you saw the elaborateness of that time. You saw ropes, belts, ignition blinds, cords wrapped around her neck, hang on to do everything. You just heard that when you're doing all this, you're sweating. Sweating the storm. Where is the DNA? Where is the DNA on all the rest of this stuff? Here's a guy who makes sure there ain't no DNA in this whole house. On nothing. No ropes, no clothes. The knives that were up in the room weren't tested, but be that as it may, no DNA. But then you look at the picture, the final items that are used, allegedly, there's DNA. No fingerprints, no anything. But, and then I think the scientist, Miss Simon told me, even on those items, how much DNA? I don't have to recap that for you. You know, we're talking about minute amounts of DNA, period. You're going to have a lot of evidence back there, and they're going to want you to kind of skip over, but you wonder, in a lot of these DNA samples, you know, especially like when Miss Simon did the dryer and the curling iron, you're asking, well, Agent Durst was specific about where these were, and that can be important for transfer. But Miss Simon says, well, but I can't tell you where I got the DNA. I don't know if it was on the cord, on the handle, I don't know where it was. You know, you want to know, because how easily DNA is transferable. You just want to know. Ladies and gentlemen, there's a lot of speculation that the state of Ohio wants you to do in this case. As I thought about it last night, you know, the state of Ohio has a duty to prove each and every element of each and every offense. You're going to have to jump to some conclusions because things weren't proven. So they want you to assume that everything that happened to Rachael Anderson, right, happened between the hour and a half, between 7:59 and 9:25. And they want to establish that time by what? And so you get to go back and look at that. And you keep that in mind, knowing that somebody used her car on that night, and somebody bought that car back. You use that in light of what Dr. Daniels told you in terms of the times. for the mortis. What is that? Rigor mortis, liva mortis. I lose myself sometimes. Please bear with me. But he told you, he said 24 hours or 3 hours. You can look at the damage. You can see what happened. 24 or 3. State of Ohio wants you to say, well, you know what? DNA, STR DNA, was found inside of Rachel. Nobody came in here and told you that those vaginal swabs were from the inside of her vagina, did they? They want you to assume that they were from the inside of her vagina. They could have been vaginal swabs from the outside of her vagina. You never know. They will say, well, no, how did the YSTR, that ain't even his, it could have been his, get on the inside of her vagina? They ain't bringing in somebody and say, you know what, these swabs came from the inside of her vagina. I want you to assume that. They have a duty to prove it to you. They have a duty to bring somebody in here to testify to that. You can't just assume. Where did it come from, ladies and gentlemen? Ask yourself, you tell me. You're going to have to say, I think, because I'm nobody in here, I think they came from the inside of the vagina. Folks, I want you to bear with me. You know what? As I've gotten older, they keep making print smaller. They keep making it smaller. I want to get on them about that because ain't nothing happened to me. I know it's the print, so it's a little hard for me to read. But bear with me a little bit. I don't want to go back and cover everything. And I know you folks are saying, well, Larry, during the cross-examination, you brought up names of several individuals and the reason you were bringing those names up. And we talked in terms of John Kennedy a lot. And you're going to see that a lot of times you can actually see the turn in an investigation. When it turns from being an actual investigation till it turns into an information gathering process that has to lead towards conviction. And so you have to draw the line, not really that hard, because Detective Martin Hughes told you. Once Anthony Pardon was identified as a suspect, what happened to the investigation in this case? And we're talking about February 8th, ladies and gentlemen. He told you. It became an information gathering process to convict Anthony Pardon. So everything done after February 8th was done in order to convict him. So they stopped doing an investigation. So I said, well, Detective, how do you eliminate any other possible suspect? Because even from Rachel's brother John, he said, listen, when this happened, and he was reluctant to tell it, but he got out, we initially suspected John Kennedy. Why? For several reasons. For several reasons. John had some issues, and he felt a certain way about Rachel. And there were sexual vibrations and etc. There was arguments, he's calling her names. He had an interest in her. And so, we said, well, Detective, we understand he's the suspect up until you identified Anthony Pardon, but what did you do? He said he had an alibi. John had an alibi. Because that's what I'm saying. With the state, they want everything to happen during this particular period of time. Okay? But there was a large period of time that's unaccounted for. A large period. So you said, well, John had an alibi. Yeah. What was his alibi? There was no male DNA on that knife. Did you stop there? Did you stop there? Why do you stop there? Because the suspect in this case is a male. And we don't want nothing that leads us away from him. I asked again, I said, Detective Howell, that good work that the state of Ohio is relying upon for this geo-tracking. You know what I mean? Did anybody check your work? No. No, nobody checked my work. So you ask yourself, ladies and gentlemen, you went in, you wanted a procedure or something done on you, and the doctor told you you had a problem. You asked the doctor for a second opinion, and he said, it's okay, I'll give you one. You got a problem. Is that a second opinion? Is that checking the work? It's the same guy telling you the same thing. When he talks about this work, that's why he wouldn't go as far as to commit as to say when he drew all those circles up there. What does that really mean? He couldn't tell you if he was in any apartment. If he ever went in any apartment. He could have. That's good enough. That's good enough. If we can put them near, then we can get jurors to make the connection. That's all we want. Put them close. I can put them close a lot. Anybody check to see if this is accurate? You got problems with iPhones, but you're doing tests with iPhones? He told you. If it's off by a few feet, it's off, throws everything off. He told you he left out plenty of evidence in this case. Now, do you think that evidence was favorable to Anthony Porter? We sit here. One of the reasons that today, in this modern time, you can't get away from videos. You can't. They're everywhere. And they help you folks in making decisions. And when Anthony sleeps, when you watch his interview, he keeps telling the detective, the person I got this card from came out of this store. And we talked for a few minutes. And it's on video. Now, you've seen, based on the timeline that the state created, how many minutes you have before the use of that first credit card and that decline versus the video and the time that it was ordered. Yeah, we would like to have it. We don't have it. But it's not Anthony's fault. You could see who was on that video and who was driving that. But guess what? We ordered the video down to the last minute. So things that would be helpful for Anthony Parton don't exist. You have pictures of Rachel's apartment. Again, you don't have to make a big jump, but the reason they said that there's a robbery, because they want you to think that if this credit card is out here being used, it was taken. There's no evidence of that. And well, what do you think, ladies? You think Rachel gave who what? We don't know. That's not your job. That's the state's job to show you that. But we look in the apartment and nothing's taken. You know, you got a computer there. You got her phone. You got numerous items on the table. I asked Agent Dirk, she go upstairs. Ain't under the dresser drawers pulled out. Nothing disturbed. Somebody said, well, maybe that's not the way she kept it. Nobody came in this courtroom and told you that was not the way she kept her apartment. Her brother was there the day before. What was disturbed? What was in disarray? Where's robbery? Where's the evidence of the robbery? And where's the evidence that he committed a robbery? Burglary, trespass. Again, we want you to take this big leap, because we're going to fill in this puzzle. But we need you to take leaps to fill this. Where is the burglary? We think, and there might be many theories, that the door was unlocked so somebody must have came in. Somebody might have been let in. We don't know, but we want you, folks, to say somebody trespassed. What evidence was put forth in this case to say that? That connection, that working backwards. Credit cards working backwards means they had to be taken through some kind of stealth or trespass. Not frontwards. Where's the evidence of the trespass? Fill in the puzzle. Have to assume yes. What logical person would allow somebody to... That's not the point. The point is proof beyond a reasonable doubt. You got to be firmly convinced it happened by the proof that the state gave you. Not by speculation. Not looking at the nature of this and saying, well, you know what, it had that. They have to prove it to you. You might think that. I think that wouldn't happen. I think it is not proof beyond a reasonable doubt. The state has to prove it. I know it did, because the state proved it to me. The rape. You know what the evidence of rape is? Because the way her body was found with nothing on the bottom. Okay? And so, well, no, the vaginal swab. And nobody come here and told you that was the inside of anything. No penetration whatsoever has been proven in this case. None. But the way she was found, well, why was she found without no clothes on the bottom? That's your proof. There's no direct evidence in this case that Anthony Parton did anything other than use some credit cards. None. They want you to tie his conviction to where that phone went. And they want you to conclude that phone only went where Anthony went. They didn't prove that, but they want you to conclude, well, listen, if that's Anthony's phone, and he's where the credit cards are used and the phone is there, then he did this. Then he did this. And ladies and gentlemen, I don't think that's filling out a puzzle for you. Again, with that DNA that they want to say was his DNA in the department, folks, I need you to, again, look at the circumstances. And does it make sense in terms of the totality of all the circumstances here? Somebody would remove every other sign, but in the most obvious places in the world. You know what? I'm going to take all my DNA from everywhere else, but in these particular instances, I'm going to put it here. You have to use your common sense in terms of that. And Judge McIntosh is going to give you a copy of the jury instructions in this case. And this is the law, and it tells you what has to be done, what law you are to follow to apply to whatever facts that have been proven beyond a reasonable doubt to you. And ladies and gentlemen, I think that once you had an opportunity, and I always say this, you know, I don't like saving it till last, she'll tell you first, but normally, jurors, I think of a few things, but they ain't nothing like what y'all think about collectively. When you get back in that room, there'll be some thoughts about subjects that I didn't even think about. I'll be amazed at sometimes what jurors think about. And I know with this cross-section, there's probably going to be a lot of that goodness coming out. And so regardless of what your verdict will be, we will respect it. Me and my co-counsel appreciate the fact that you paid attention, that you gave us your word, you would listen to all the evidence, and we think you have. Now when you go back there, you'll reach whatever logical conclusion you can based on what you've heard. And I'm sure there's some things here that I missed that occurred to people, and I wish you shared that with other members. But anyway, ladies and gentlemen, we do appreciate your time and your undivided attention during the process of this case. So thank you very much, ladies and gentlemen. Thank you, Your Honor.
Thank you, Mr. Thomas.